thank Tony and Peggy to start off the incredible campaign they really helped put together. Just an interesting point I think to start off was with the point John actually made with regards to the cold and calculated approach by defence lawyers. But I should just like to take back to the first ever time I met Brendan McConville, and I tell this story with great embarrassment and regret. I walked in the room with Brendan, and it was at the time when bail was obviously a consideration, and obviously no papers, and I made seeing no evidence at this stage. And as a defence lawyer, you always have to take the approach that you have to be careful, you have to be mindful of your client's interest. And I'll never forget the moment I said to Brendan, as long as I live, I'll never forget it. I said to him, we were talking about the tracking device, we were talking about the forensics, and I remember saying to Brendan, do we really want to push it at this stage? And I'll never forget, he leaned over the table and said to me, Darragh, I'm an innocent man, push everything. And at that moment, I realised that this was not a standard criminal case. This was verging on one of the biggest miscarriages of justice this country will ever see. And I still reiterate that. I think that's what it has become. I think John has outlined very, very clearly the facts and things regarding the actual case. I think Catherine actually made a fantastic point with regards to the original trial and the campaign that was ongoing with regards to Mrs. Carr, the grieving widow. I don't intend to take away from she's entitled to her grieving, and I'm understanding about that. But what I think people may have forgotten about in the original trial is there's two families, and they're both sitting in this room, who are now grieving for the loss of their loved ones. They have to go down to HMP McGarry to see them. They can't touch them, they can't bring them home with them. And that in themselves, I can't say this with enough emphasis, these two men are innocent. But I'll leave that for your own consideration after we obviously outline the legal issues. Just to put in the brief context, as John outlined as well, witness M was an absolute significant part of Brendan McConville's trial. He was the man who said he identified Brendan as he walked from supposedly the scene of where Constable Carr in the vicinity to a relative of his house, a relative of witness M to his house with his partner, his dog and his partner's child. And where this becomes important obviously is in the grounds of appeal. We obviously discredited completely witness M in the original trial. Things that regard the distance witness M previously outlined that he had seen Brendan McConville was 16 yards. Brendan Kelly, the QC, cross-examined witness M. He asked him, do you wear glasses? He said no. Are you sure you don't wear glasses? No. Could you have seen Brendan McConville? He said yes. The relative of witness M, when we spoke to him, told us witness M does wear glasses. He went one further and gave us his prescription. When we actually put this to witness M in the original trial, he denied that it was his, number one. Second of all, he then said that they were for fashion. First fashion accessory I ever heard of coming out of Specsavers, but that's a different point. The third issue, the most important issue, is the prosecution expert actually accepted. The prosecution expert actually accepted he couldn't have seen him from that distance. And that is what you're dealing with. That's the crux of this case, this witness. To put that all into context, obviously, this relative at the original trial said because of his connection with the witness, he would not come forward. And because of the mental condition of witness M, he would not give evidence. He refused to give evidence, and he would not give a signed statement. On the day of conviction, Peter Corson out of our office went and met this relative and asked him to come forward and give a statement to right this wrong, and he agreed to do it. A number of months later, myself and Peter actually went down to see this witness in his home area and asked him now to right this wrong, to come and give evidence, to which he blankly refused. He says, I cannot go to court, but I will sign your statement. In this statement, which took, I'd say, some 4 hours, he included massive points. Witness M does wear glasses, as he previously corroborated with the prescription. Second of all, witness M's partner didn't have a child who had been a pram at that age. Fourthly, the house to which witness M said he arrived at that night on his route to which he witnessed Brendan McConville was this relative's house. This relative said he was not in the house that night. And why this is the most important point, this was never, ever corroborated by the police. The police never went to check this relative's house to corroborate that account. Never. And where that comes in, crucially important in this case, is the minute this statement was served by ourselves on the prosecution, the police visited this man. he then became an interest to the police. The police then first of all approached him and asked him what was the purpose of the affidavit, and what he replied was, "It's all true, it's all true." They then said, "It's not true," and his instructions clearly to us were that they told him if he attended court that they would discredit him. What happened then was some days later we actually made a phone call. We couldn't get access to this relative. It was great difficulty. We eventually had a phone at a bar just to get him, to which he told us that he no longer had a phone because he was being tortured by a number of people, ourselves included, believe it or not. He then also said that he didn't want any involved in this. He had enough. His family, everything, the whole of this case, he just wanted to know no more. He also did tell us the police had come to his house. On that day, we lodged the police ombudsman complaint on behalf of Darragh McConville to say that the defence witness had been approached by the police, and the most importantly that this witness was known to police some years before, at the time of committal, when this witness gave this man's name to corroborate his account and was never approached. What then actually transcribed was a further few days, it was a Tuesday, we still couldn't get this man. There was no finding him. And I actually took a Saturday, we went down at 2 o'clock, we went into a bar, and there he was sitting there. I'll never forget, Jerry Conlon actually of the campaign was with me, and I said to Jerry, there's a fair chance this man's going to come around and hit me here, so do you maybe just want to stand to the side for a minute? So I walked over and I was completely surprised by his reaction. He turned around to me and he says, "Come into the corner, I need to speak to you, I need to speak to you." So went into the corner and he sat down, and what then transcribed was this man had actually been arrested by the police. He'd been held for 3 days and questioned for an offence which was, as described by police, withholding information likely to be used to an indictable offence. I'm still unaware what the indictable offence is. Then transcribed was I spoke to him, and which mostly became worrying was he put to me my movements about meeting him, where I'd gone to, namely at Mr. McConville's house beforehand. He put to me how I'd met Peter Corrigan in my office in a certain place. I'm still unaware how he would have known that information. We then obviously put the Court of Appeal on notice on the Friday, or Saturday, that we would be making significant representations on the Monday morning in the Court of Appeal. That this process had been prejudicially affected by the conduct of the police. We then received a letter back on Sunday, I think it was, from the prosecution saying we may be seeking an adjournment. Maybe, there's no guarantee. On the Monday morning we went into the Court of Appeal, and I forget Darragh Mackin's comments, and they were very, very rightly so. The police made a direct attempt to sabotage both these men's appeal. There's no getting away from that. And I don't intend to get on an onslaught with the police. But what I do intend to get at is there's an adversarial process in this country with regards to justice. And they directly put themselves into it and disrupt it. And that's a point that needs to be put in with everybody here. And they need to tell their family members about this, because what my worry is, it's not just about Darragh Mackin and John Wootton, but it's also that if this is the position in one case, what could happen in future cases? It needs to be put an end to now. The affidavit obviously was of significant importance to the actual appeal, and I think John will agree with that, and not just for obviously Brendan, not they were on with Brendan, but for everybody, because it obviously undermined the whole prosecution case. Went on then, the appeal was actually adjourned for our arguments on the fact that the appeal had been sabotaged. Obviously the Lord Chief Justice didn't want to get involved in a legal argument at that stage without any reform, so we had applied for disclosure of any transcripts that had become available throughout these interviews. And obviously we had limited instructions from this relative. What then transpired in the transcripts when we got access to them was not just only had they tried to prejudice Darragh Mackin and John Paul Wootton's appeal, but they'd actually tried to undermine the role of defence solicitors in the case, particularly myself and Peter, who were actually named in the transcripts throughout a number of times. And at one time in particular, and I can tell us this was been reported on before and things, they actually put it that myself and Peter took a statement from this witness with 2 armed gunmen with us. And that's a true story. I see people laughing, that's 100% true, and there was other obviously derogatory comments. Not just that, but like I said, that the original charge they arrested him was on the basis that he was withholding information of an indictment offence. In my opinion, I think John's got the same opinion, throughout them 10 interviews to which he's had for 3 days, the maximum time at that stage, there's not one question on this information. All these questions relate to are the affidavit, and all it is cross-examination by the police officers on this affidavit. And throughout it, he maintains that it's all true. Every single part is true. He never takes away from it. And if I want to get the issue of him, his opinion on the matters, he was independently corroborated by the psychiatrist's letter in the original trial about witness M's mental condition. He was independently corroborated by the eyewitness, or sorry, the eye expert. So that went on. Not just then, obviously, the police went a step further again, in my opinion, and I was speaking to Tony about this before. They then tried to observe the role of the police ombudsman by actually cross-examining this man on the police ombudsman's complaint we had lodged on behalf of Brendan. And that is where this appeal comes down to. The adversarial process of the court has been completely usurped by this, and the role of defence lawyers has been completely usurped. And that is a point. This case, and we're obviously, I don't want to talk about things I shouldn't think, but I'll never forget the day that we went down to Brendan McConville's appeal, obviously with members of the family and things. And it's an absolutely terrifying fact, I think, that there's a chance, and Peter agreed with me on this, that there's a chance that me or him, or both of us, will be arrested at that point in time for, we don't know, we still don't know, for having armed gunmen that don't exist. So, as that went on, we then felt the need to engage the UN Special Rapporteur, and there's been a number of our applications being sent off, and it's a lever article thick with the transcripts, with the applications to the police ombudsman, the cross-examination by the officers, and also there's been letters sent to the police ombudsman, the CHA, and political activists, human rights activists as far as New York on this case, because this has gone past the issue of appeal now as well. This has become intimidation, in my view. I think a number of people in this room will agree with me. It's now intimidation. And the point I'm all getting to is, I'm not here to try and convince your opinion. I'm not here to invite, or anyway, lecture or protest. But what I am here to do is simply to invite you all to attend in October, to attend the appeal. And I'm not asking you to attend to support John Paul Wootton or support Darragh McConnell. I'm asking you to attend to support justice and see it through. See that there actually does exist a fair and unprejudicial system in Northern Ireland. That's